Why on earth would a private practice owner think that they have any intellectual property whatsoever, let alone any IP that might be worth trademarking or protecting in one way or another? Well, my guest today is going to tell you exactly why. Today on Practice Care, I'm Carl White, principal at Mark Advisory Group, which is a healthcare marketing agency, and I'm also the host of Practice Care, which is all about bite-sized, simplified advice for the business side of your practice. And today, my guest is Lesley Wallerstein. She is the owner of a firm by the same name, Lesley A. Wallerstein, and she's a patent and trademark attorney. She's a graduate of MIT and a former patent examiner herself. So what does that mean? That means that she read and scrutinized the patent applications that she now helps her clients write and get approved. She knows how to write them, and she knows how to write those and trademark applications that not only stand up to the competition, but also stand up in court. And that's a big deal when you get into this world. Lesley, thanks for coming on Practice Care. It's great to have you.
Carl, thank you so much for having me.
So I've mentioned to some of my clients now and again, you should trademark your name. You should look around and see what kind of, you talked about this new thing that you do or this new device. And I just say, have you ever thought about patenting it? And I just kind of get an eye roll. And, in one case, a client, he's a chiropractor, and he modified a certain piece of equipment that he uses. And my first thought was, have you looked into this? Yeah, it's on the list, but it never quite gets above the line. And so, and I stare at this, I go, okay, a busy day, busy person, I get it, but man, oh man, there could be something there. Can you give us an example of a client that you're working with or that you have worked with that can help kind of open up the minds of our listeners to why this is something that should get above the line and on the priority list?
Absolutely, Carl. I'm glad you asked. So I actually represent a number of doctors. I've got a client who's a dentist, psychologist, people in the healthcare profession, and several of them have invented products or methods of treatment. This is something that you can these are your what we call intellectual property is something that is actually an asset of your business in the same way as your equipment or any other physical tangible property. This is an intellectual property that you have. And sure,
you were talking about a dentist before we kind of started recording.
Absolutely. So my client, who is he's a local dentist, invented and thought of this great, he created and thought of a completely different material that he could use for the dental surgery that he does without going into a lot of detail.
I get it. Yeah.
So he came to my office. He was so excited. He said, Lesley, you won't believe what I have done with this material, what I can do with this and how this will revolutionize this field. And, he's so excited about this. And we filed a patent application for him.
In this case, if all goes the way you guys want it to, he'll get the patent, and then this is something he can sell. He can what can he do with it once he's got it?
Sure. So what the patent does is gives the person holding the patent the exclusive right to make or sell or license the product or the method. So it's that exclusivity that is very, very desirable, and that's what's worth money.
That's what this dentist is trying to do, right?
Exactly.
Okay. I'm curious if you can say just broadly, where is it in the patent approval process right now?
We're waiting for it to be examined. We filed early last year, and sometimes it takes some time.
Okay. Well, let's hope it works out. Fingers crossed for your client. It's a good backdrop to say, because it's not something Because part of what you were saying is it's the material, but it's part of a treatment method as well. And so is that part of the patent, or is it just the material?
It's both, and we are trying to protect both the material that he is using and his method of using it.
Got
And
it.
sometimes there is a pathway to patenting something that's an old material, but used in a new way.
Okay. So it takes some creativity to figure this out. So with that as a kind of a lead in, let's just start with very basics. Like, what counts as intellectual property?
That's a great question. And it really falls into one of four different camps.
Okay.
A lot of people have heard about patents because, well, they've seen shows like Shark Tank, where the sharks ask the presenter, do you have a patent on this? And is this protected? So they're familiar with that. People have seen or are familiar with registered trademarks because they see the R with the circle around it next to the products, and they see every day.
Mhm.
Anybody who watches television knows that pharmaceutical companies invent crazy trade names for their medications that are easy to pronounce, and you can easy to ask your doctor for these.
Mhm.
So copyrights are something different and a lot like patents in the sense that they protect tangible things, and the a copyright is more designed to protect more artistic works. For example, in the context of a doctor, they might write a book or a pamphlet that they give to their patients, and that's something that you could copyright if they're concerned about other people copying what they create.
So books or materials is one. Other types of IP, like even the name of your practice. Like what are some before we started recording, I like the term you used, business assets. You have business assets. Every practice does, and some of them, are intellectual property, even as simple as the name of your practice, right? I was wondering, like, what counts as IP in that context?
In that context, your business name, absolutely, because that is how people find you. And that we call this idea, you've built goodwill in the minds of your prospective customers. And this is that's how people find you and come to you for services, is that they know your name. And they associate your name with the quality of the services that you're providing. So the name is actually super important. And it also helps you distinguish yourself from all the other people in the local area who are providing similar services.
Name, that's something that counts as intellectual property. What are some other examples you've seen, like in say medical practices, things that they count as intellectual property that's really worth thinking about patenting or copywriting or trademarking?
Sure. So inventing a product that you use in your practice,
Mhm.
like inventing a treatment composition. That's something that a doctor might be able to use. We talked about their name, the products that they invent, Not only can we protect the products themselves with a patent, but you can give them a trade name to make them easier to find in the marketplace. So I've done that for several doctors
Okay.
and medical practices.
What about, like, you take a device that's on the market and you modify it in some way because you use it in a different way, or you've improved, like you could just bend it a different way or attach something. I don't know. You think of something like really simple. Does that?
Well, possibly, and you would want to have a qualified intellectual property lawyer discuss that with you when you're talking about modifying something that already exists.
Okay. Okay. I want to go back to the practice name for a second. Because when I not what I used to think about it before I started talking to you and had my mind opened up. I would think of the name as, you trademark your name, the name of your practice, ABC Orthodontics, for example, because you don't want anybody to take it from you. And I think one of the popular maybe beliefs about that is, well, would that really happen? I mean, what's really, that would never happen. It's almost dismissed. And it feels like trademarking your name isn't worth it as a result because, that would never happen. But the other side of the coin is, look, the likelihood of that happening is probably quite low. Let's just say that for the sake of argument. But if it happened, I mean, imagine the pain. Imagine you wake up and you go, you check your mail one Monday morning and there's a letter from a lawyer saying you can't use your name anymore. You have to change the name of your practice. Can you imagine? So, the idea of patenting or going through a lot of work to mitigate a risk that you think is unlikely doesn't seem very palatable. But, can you respond to that and,
Oh, sure.
try to, hey, you should rethink about that because.
Right. So this is where in any of your customers' businesses, they might have a general counsel who can kind of clue them into this in advance. So it's like a lot of the advice that doctors give their patients is the advice that I give to my clients is that protect yourself early, and you will save yourself a lot of pain.
Yeah.
Later on, it's always better to ask the question up front. If you're choosing a name, I can't tell you how many times I've had to fight for people who either didn't apply for a trademark right away or waited too long to get it. So, or they let it lapse. I mean, I'm fighting, and this is not in the healthcare industry.
Yeah, that's okay.
But just case in point, I mean, I represent a nationwide manufacturer of pizza, for example, and they had a trademark for many, many years, and the ownership of the company changed hands, and the trademark slipped through the cracks, and I am fighting to get it back. And it's cost them a lot of money and a lot of time. I'm still fighting now. And I use the word fight maybe overstating it, but it's so, I can't tell you how many times that I've had to go in after the fact and kind of correct what it might have been more cost effective in the long run to have looked into the trademark, looked into the company name before choosing it. I can't tell you how many times, Carl, if I had a dime for every time.
Dimes. So that situation is they had a trademark on a name and then they let it lapse and now they can't use the name anymore. Is that what you're saying?
That's a different question. Can they use it?
I'm just in that example you just gave. Because we were talking about a practice name and the value of trademarking it.
It depends. It depends 100% on there's a difference between using a trademark, having the right to use it, and having a registered trademark. And that is going to get a little more technical than perhaps your audience would want or need to know.
Is it the value of trademarking your practice name or your business name?
Say it again.
The value, is there a value of trademarking your practice name?
That you get it trademarked early, and you can exclude anybody else and everybody else from choosing the similar name for similar services.
Right. Yeah, and we live in an area, we live in a region of Chicago called the North Shore, and if you use the words North Shore in your name, which a lot, and not just in medical or healthcare, if you use that, you've just given yourself an advantage. So my world and the marketing world, when somebody searches, they go online and search for, a provider of this or a service that, they'll very often put, North Shore, fill in the blank near me. And if your name includes North Shore, you automatically, all other things being equal, are going to pop a little higher in the search results, which is what you want. So, if you live in if where you live has a popular name for the region, like Fox Valley is another one. They're like far western regional suburbs. You are the Fox Valley this or the Fox Valley that, and lots of parts of the country describe themselves that way. If that's part of your name, you might want to think even a little harder about trademarking it, because, put aside the fact that somebody else could do that and then take it from you, and then you have to change your name. You just trademark something that's a really popular way for your customer base to find you. And then you could decide how aggressive you want to get to make others stop using it. But imagine if you were the only North Shore primary care, but there's lots of other primary care practices on the North Shore. If you really wanted to push it, you could make them change their name. Is that right?
Could you say that again?
So if you trademarked North Shore primary care, so you're North Shore family medicine, you're a family practice, and anybody else who had the words North Shore who's a competitor to you in their name, you might be able to take some action if you really wanted to. I mean, that's a pretty bold move, but yeah.
You could, and you have to, there is a cost.
Sure.
To enforcing your trademark rights, but it's important to do that.
Yeah.
Because if you don't, then people will, it will diminish the value of your trademark. If other people come in and begin using it, becomes, we see this in a lot of consumer products that have become, they become generic because people overuse the trademark, and the company doesn't do anything about it.
Like Kleenex, right? The classic example. Xerox. Yeah.
Right.
Yeah.
Right.
Okay. All right. What are some of the more popular objections you hear? I mean, by the time a client, somebody gets to you, they've gone through them and they've decided at least want to really think seriously about starting the patent, the copyright, that process. But for those who don't get that far, what are some of the more popular objections you hear that just say, I don't want to do that. It's not worth it because.
Oh, sure. Because it's initially, the cost can initially be a turnoff.
Okay.
And, the government has filing fees and we can't do much about that.
Okay.
But what I say to a lot of my clients is, don't you want the peace of mind to have done the due diligence up front? Is that not worth it? I mean, you're spending all this money on marketing, you're spending all this money on manufacturing. So don't you want to know that you have the right to do this before you spend more money and more time and more energy, before you get really, really invested in the name or in the product? It's so important. So this is something that I share with my clients, and a lot of them respond to that.
Yeah.
Another objection that people sometimes have is, they've had bad experience with other attorneys in other parts of their life. And they think that it's going to be difficult to deal with an attorney.
Okay.
So what I would say is that there are many attorneys out there. You can choose somebody who you like. You can choose somebody who's a good fit for you and you feel comfortable with. You want somebody who's going to respond to your questions. You want somebody who's available, who answers the phone or email promptly. And you want somebody to explain in layman's terms, what you can expect. How much is it going to cost? How long is it going to take? And what does this mean? So it's really important you find an attorney who will be that person for you, kind of walk you through the process with you.
Right. Absolutely. Absolutely. And you said something, you mentioned marketing. So that's what we do. And so I thought, what the thought that hit me was, if a client of mine had something that was patented, something that they used to treat patients with. I'd certainly want to know more about it. And, presuming that it works as it delivers on its promise, adding to the fact that it's patented makes it, more compelling. I think all of the things being equal to a prospective patient base to say, we have this patented method or we have this patented thing that we do, that, and we know we're the only ones because we got the patent. So if you want this extra benefit, you got to come here to get it.
And it's what I say. So we offer, my firm offers a service called a provisional patent application.
Okay.
And the beauty of this, it's a very easy and relatively quick way to get your skin in the game, in the patent game, and get you a place in line at the patent office. It gets you patent pending status, which a lot of people have heard because they've seen it on products that they use every day. Yep. So that phrase is marketing magic. I tell my clients that it doesn't necessarily mean in a legal way that what you've got is so unique. We don't know that yet because all you've done is you filed the application, but you did file the application, and therefore your application is pending. So it's great language to use.
Yeah, perfect. Well, we could, as I'm sure your professional life is devoted to intellectual property, so we could spend a lot of time on it. But in the interest of kind of bringing us to the finish line, a couple of questions I always ask. The first one is there anything you think I should have asked you that's, in the context of what we've been talking about, that's useful to our listeners, but just didn't think to ask?
No, I mean, I would reiterate that if your customers are even thinking about any of these, to talk to a qualified attorney and don't do it themselves.
Okay. And the other question is, if somebody listening wanted to kind of get moving on this, what are one or two tangible steps they could take? And one came to my mind, which is look at your practice through fresh eyes, through these eyes. Is there anything that we've done, anything that we've modified or created, whether it's something tangible like a device or a product or material, or even just a different way of treating a patient or doing something that's different than what the standard of care is, or not standard of care, but that's different than what everybody else is doing? Start a list. Just make a list. Like that's your business asset list, that some of which might be worth, going down the intellectual property, trademark patenting route. That's one thing, I would think.
I mean, I can't think of anything else. I was going to, the only thing, the most important thing that your customers should ask, that any business owner should ask, is what am I doing that's different from everybody else?
Yeah.
And see if they can and make that official and make that legal.
Yeah. And then if you really, and you've done something novel and it just seems to be, your patients are really benefiting from it. And if you've been in your field for any amount of time, you're going to have some sense, I think I just do this better. I talk to colleagues at conferences or whatever, at dinners, and, they describe a problem that I feel like I've solved. You might have something.
They very well might.
They might have something. Yeah.
And it's really important to move on.
Yeah.
How many times people have said to me, God, if I had only, I thought about this years ago, I wish I had patented then, because now I see it everywhere. Right.
And there's part of the thing I was asking about earlier, it's that regret in that moment is not because it impeded your ability to do business, right? So like somebody took your name. Now you've got an impediment to doing business. That's the risk mitigation. But the regret is, just to say it brass tacks, look at all the money I could have made.
Yes.
Because I had this idea before those people, but they acted on it and I didn't. And, you might be sitting on something really valuable, and there's no harm in thinking about your practice from fresh eyes and saying, do I have something that other people could benefit? If you have something that other people could benefit from, that you you can't find anybody else doing, there's your start. You're at the starting line. Now you just got to, get up and start running down. Perfect. Well, thank you, Lesley. Thank you again. We appreciate you taking the time to come on Practice Care. We will put all of your contact info in the show notes, but is there a preferred method that you have for people to contact you?
No, my website has all of my contact information, my phone, my email. I answer the phone and I will respond to email.
Perfect. And I can vouch for that. Very, very prompt. Well, thank you. A couple of other points before we wrap up. If you are people like Lesley and me, and you serve private practice owners, or if you are a private practice owner, and regardless, you've got a good experience that you want to share that you think private practice owners will benefit from, then we want you to come on Practice Care. There's a link in the show notes to go to our website where you can fill out a form and get yourself scheduled as soon as possible. We want you to come on and tell the world about it so they can benefit from what you know. And finally, please, if you haven't done so already, please subscribe to Practice Care on Apple Podcasts or wherever you listen to your podcasts. Thanks very much, and until next time.